Who built the Grace Arms apartment?
I'm not sure who got the bills or who made the contracts with the subcontractors.
I'm not asking who was on the contracts now. I'm asking who built the buildings.
Well, we had subcontractors.
Well, who was the general contractor on that job?
I'm not sure how you're using that term.
Well, I'm using the term as it's generally used in your industry, in the construction industry. You've heard that term before, right?
Sure.
Many times?
Yeah.
And I'm assuming you've used that term, general contractor, in your conversations?
Yes.
Many times?
Yeah, that's...
And so, what does the term general contractor mean to you? Just a minute. You can't confer with the witness while the deposition is going on.
Yes, I can. That's what the right to counsel means, the right to confer.
You can confer before the deposition begins, but not after it begins. Besides, I just asked a question. There's a question pending. You certainly can't confer while there's a question pending.
I can if he needs to talk to me about whether the information you ask calls for the disclosure of privilege information.
What does the term general contractor mean to you?
It means the contractor who has signed a contract with the owner to take overall responsibility for the completion of the project.
And does the general contractor have the authority to hire subcontractors?
Yes.
So who was the general contractor on this job?
I'm not sure.
Let me ask you this way. Did Acme Construction Company serve as the general contractor?
It might have. I guess it did.
Did Acme Construction Company people work on the Grace Arms apartment project?
There was a superintendent.
And who was that?
Well, there were 5 of them.
Do you recall their names?
Dale, Richard.
Do you know their last names?
No. Matt and Robert.
If you wanted to find out or refresh your memory on the names of the superintendents on that job, where would you look?
I would look in my logbook.
And you have your logbook here as Exhibit 19, is that correct?
Yes.
Let's look at Exhibit 19. Is that the logbook for the Grace Arms apartment job that
Yes.
you maintained?
Yes, it is the logbook for the Grace Arms apartment.
Would you take a minute, review it, and let me know, tell me who the 5 superintendents were that are listed in your logbook? You have pointed to Dale Smith. Was he one of the superintendents on the job for Acme?
Yes.
And Richard Jones, was he also a superintendent for Acme?
Yes.
And you've also pointed out Matt Walker and Robert Martin. Were they both also superintendents for Acme on the Grace Arms apartment job?
Yes.
Now, you initially said 5 superintendents. We've found 4 in your logbook. Do you think there was another superintendent?
No, I was just estimating. There are only 4 recorded in the logbook.
So have you exhausted your memory, or has your memory been refreshed with regard to who the superintendents were on the job at Grace Arms Apartment on behalf of Acme Construction?
I can't think of any others right now.
we're going to be asking you some additional questions, but if you remember or recall the other fifth superintendent, please let me know. Is that fair?
Sure. If I can think of anyone else, I'll tell you.
Thank you.
Let's talk about the issue that arose during our last vignette about the right of the lawyer to confer with his or her witness during the course of the deposition. This is a particularly important topic because the federal rules do not specifically address it. Federal rules of procedure cover a lot of issues relating to the taking and defending of a deposition, but for some reason have omitted reference to the right of a lawyer to confer with counsel, with their client, or any restrictions on that ability. And the rules of practice on this area vary widely from state to state and from federal to state. So, what are the experiences that you have encountered with whether the lawyer is allowed to confer with the client during the course of the deposition, under what circumstances it can take place, whether the client can then be examined about that break, and whether the witness is required to answer pending questions before the break is taken?
You know, it's a very difficult subject. I tend to take the approach that there is guidance in the federal rules, at least, under 30C1, which talks about the deposition should be conducted as if it were in trial, with a couple of exceptions. Exceptions, of course, objections and preserving them, and the attendance of people at the deposition. I don't think most people would argue that you're going to see attorneys between question and answer asked to speak to their witness unless there is a privilege at issue. And then usually that would be dealt with. So I think that is somewhat clear, at least in federal court. Whether or not you can confer with the witness during breaks and other times, there is no prohibition against it, and unless there is a specific rule, I think we all tend to do it. So I think that's the only guidance, but clearly what happened in the vignette, in my estimation, is not appropriate.
Yeah, I would agree. I have utilized, and all the lawyers in my firm have utilized over the years, the civil discovery standards of the ABA that were first published in 1999 and then modified and updated in 2004. And essentially, those guidelines are just guidelines, but because they're ABA guidelines, most attorneys that I deal with across the country, regardless of jurisdiction, seem to, if you cite them, realize that they're probably something they should follow. And basically, you cannot have a conference while a question is pending or during a deposition, except, as they point out, to determine whether a privilege should be asserted. But during a recess, it's certainly appropriate, according to the guidelines, to speak with the witness if you're the witness's attorney. It's certainly appropriate over a recess for the evening. But I always ask whether there has been that discussion, because most attorneys, if you're cordial, will say to you, yes, we discussed, and whatever they discussed. Because I want, if there's a clarification, I want to know that then.
Right.
If there's going to be something that comes up because of that discussion, I want to know it now,
Will
not later.
the lawyers typically allow you to inquire as to the specific substance of the conversation, or just the subject matter?
Sometimes it kind of depends. But at least you're putting it on the record,
Right.
and it's on the record that there was a discussion. And if the witness or the witness's attorney is not forthcoming, then if something comes up later, I think a judge would look at that and say, well, you should have revealed it at the time.
And it might also help discourage conferences if you show that every time a conference is taken, you're going to make that kind of an inquiry.
Right.
Yeah.
I tell my witnesses, my clients especially, if you need to take a break to ask me a question because of the question or questions that are being asked, feel free to say, I want to take a break, we'll go out and talk, and then I'll tell the other attorney that we had a discussion and why.
I think clearly you can ask whether or not there was a discussion. I would not allow my witness to give you the subject matter of the discussion. However, I do think it's very appropriate and probably you should do it, is to ask the witness if anything has occurred since we took a break that leads you to want to clarify any answer you gave, so you have that on the record, and so you can get that information, and I think that's appropriate. One of the issues that I tend to have in depositions is, well, when you have an attorney who wants to talk directly to his or her client. In other words, they don't care about breaks. They're simply going to say, Joe, don't do this, or Joe, remember this, or Joe, that, right on the record. How do you deal with that?
Well, I think most lawyers will object to that. The federal rules do provide that objections cannot be instructive. They have to be concise, non-argumentative, and non-suggestive. And what you have described is exactly suggestive. That's the whole purpose of the interruption, is to suggest what the witness should or should not do. So I would hope that the lawyer who was attempting to make an inquiry, who's asking questions of a witness, and the witness is being handed suggestive statements from their lawyer, would promptly object to it, and if the conduct continues, should seek a court ruling on that.
The ABA civil discovery standards address that also, and it's amazing to me that if you cite the ABA civil discovery standards or guidelines, a lot of attorneys are surprised, first of all, that those exist. Secondly, you have them there. We have all of our younger attorneys always carry them with them to the deposition, and you show them the guideline, and sometimes it has the effect, unless they're total jerks, of sort of ameliorating the situation, and you can work that. I'm a big believer in trying to work things out.
Exactly.
I just want information. I want answers. I want to know for sure when we go to trial what those answers are going to be.
These ABA standards can be adopted on a case-by-case basis by the parties to govern the deposition, so that what's being done on one side's depositions is done on the other.
It's a good idea.
I do want to caution anyone watching this tape that on this particular issue, be very clear of the local rules relating to the permissibility of witness conferencing. Of all the topics that are going to be addressed, this is the one where there is the greatest variation from jurisdiction to jurisdiction.
And from judge to judge.
And from judge to judge, even within jurisdictions. So, for example, in the Eastern District of Pennsylvania, more than a decade ago, the Hall versus Clifton case came down, which established the rule that if there was any conference that was made during the course of a deposition, there would be no privilege applicable to that meeting. In other words, the judge ruled that it was inappropriate for there to be any discussions between lawyer and client once the deposition started. And if there was a conference in violation of that rule, there'd be no privilege applicable to it, and there could be complete examination of the witness as to everything that the witness said to the lawyer and the lawyer said to the witness. And it didn't just apply to interruptions during the deposition, but during any natural break, including during recesses, during lunch, during the evening hour on a multi-day deposition, or during any other break. Now, that rule was followed by most of the judges in the Eastern District of Pennsylvania, but not all of the judges even in that district. And most courts have rejected the rule. And some have followed it, but most have rejected it. And you have to check in the federal local rules, which are sometimes in the local rules and sometimes in the case decisions of the individual judges, or the magistrates as to what rules they are applying relating to the practice of allowing conferences, when a conference can be taken. Now, some states have adopted rules on this subject in the last 10 to 15 years. Since the late 90s, a few states have been adopting rules on the subject. And what I have seen is the prevailing rule adopted by the state, most of the states that have adopted rules on the subject, do allow conferences. They are permitted to be conducted in a privileged manner, so long as they are not taken when there is a pending question. If there's a pending question, the question must be answered before a conference can be allowed, before a recess can be taken, unless the conference is needed to protect privilege. Now, in the vignette that you showed, the question had nothing to do with a privileged matter, and it was probably a false excuse for the conference. There has to be a good faith belief that there is a risk that there will be a disclosure of privilege in order to be able to exercise the right to confer while there's a pending question. So typically, when a question is asked, it has to be answered before a break can be taken. In the states that have adopted this particular rule, which I call the West Coast rule because it's mostly West Coast states that have adopted the rule, the states will permit a conference, will allow a reasonable number of conferences as long as it's not interfering with the orderly taking of the deposition. But again, check the jurisdiction in which the deposition is being taken. Often, it may even differ from the rules of the jurisdiction in which the case was filed. There may be differences between those rules. And by far, the best way to handle it is to work out with opposing counsel what the agreed rules will be for the depositions throughout the case. And if there are multiple depositions, make sure that everybody is in agreement as to when conferences will be permitted, whether pending questions must be answered, and whether the conferences will be subject to a privilege protection, and what amount of inquiry will be permitted about the fact that there was a conference, the length of time, typically the general subject matter of the conference, and also I think a good prevailing practice is to require that a witness who wants to change an answer because of the conference do so promptly at the end of the conference. The vignettes that you just demonstrated show the tight-lipped deponent to be charitable, a deponent who is not interested in freely disclosing the information that he or she has. And I'd be interested in your comments on what techniques you believe are most effective in dealing with a witness who is deliberately creating difficulty and making it hard for you to get the information that ought to flow more freely.
Well, there's a number of different techniques, from anywhere from going to the court all the way from deciding that you're going to control the situation yourselves. I tend to think with most lawyers, especially newer lawyers, the goal should be to handle it yourself. And a few things you can do, and we saw a few of them in the vignette. One is to ask short questions, very precise questions that make it more difficult. To be prepared to define the terms you are using, similar to what we saw in the vignette, by adopting the witness's own definition of a word that's being called into question. And the most important thing is control, is not to change your way you're proceeding, not to get upset, not to raise your voice, but simply to keep going and to convince that witness that we are going to proceed and we're going to get the information that I need to get. And that type of technique is not going to cause me to be upset, to raise my voice, to lose my professionalism. We're just going to proceed. And if it takes 5 questions instead of 1, that's okay. That's, in my opinion, the preferred way.
Demonstrating your resolve that it's going to be done, and if it's on his timetable, it's still going to be done.
Exactly.
I think that's good advice for a lot of things that occur during a deposition, is to maintain your pace. Do not engage with the deponent or the other attorney, but rather continue to be very deliberate, but clear that you're going to get the answers. And I think, make sure, we all sometimes in depositions start asking questions that aren't as concise and clear as they should be because it's just a habit of the way we speak. When you have a witness who is not being cooperative, you have to be very clear, very concise, and define terms. I always like, as the vignette did, I ask the witness, what is your definition, or how would you define whatever the term is that he or she may be quibbling about?
Right.
And then also, again, just make sure that every question is so concise that anyone reading the question would know that this witness should have an answer to it.
Is being obviously evasive by refusing to answer.
Right. And it also depends a little bit on whether this witness is just a witness or whether this deponent or witness is an employee of the defendant company or the plaintiff, or is either a party or an employee of a party, because then you can hopefully work things out with the attorney more so than if it's just a witness. And one of the things that I think you always have to remember is that if you start being angry or express yourself to the deponent in a way that is inappropriate, you're defeating your purpose.
Right. You lose control and you want to keep it.
And I wouldn't call the judge on something like this.
No, it's hard to convey to the judge over the phone what is occurring.
There's a couple of technology things that I found helps with this witness. One, if you have a situation where you can arrange with your court reporter so that you have, utilizing a computer, you can see the immediate transcript. Because when you're dealing with that witness, you want to make sure that your questions are very precise. Don't like that technique normally, but if you have a witness, you can look at the question as after you've answered it. Maybe you need to shorten it, maybe you need to clarify. That might help, especially if you don't have a lot of experience. The second thing, and again, you have to judge this beforehand, is video depositions. Because I believe witnesses are less likely to be jerkish, I'll call it, if that's a word, if they know that someday it's going to be there. As you mentioned, it's hard to convey to a judge how difficult a witness is going to be. It's also difficult to convey that to a jury. However, a video kind of tells it. And if you put someone on a video, that sometimes loosens them up. But that assumes you know that they're going to be that way. You really can't do that in the middle.
One thing you mentioned just is using real time.
Yes.
I tell all of our attorneys that if the witness that you're taking the deposition of is important enough to have their deposition taken, then it's important enough for you to have real time, meaning you're seeing what the witness is saying, what your questions are, and I will utilize the witness's words, later. Now, the witness will say something, and then you get to another question where they're being a little bit recalcitrant. You go back and you use the witness's own terminology. It's very helpful. Also, if it's a witness that is an employee of a party, many times you're happy if you end up with the question, so to be fair, you don't know the answer to the question, and have a very concise question so that you've pinned the person down, they don't know, or they don't remember. So sometimes don't know and don't remember, and it's not likely that your memory could ever be refreshed, is just as good as whatever an answer would be.
So let's cover the important rules that relate to the discussion that we've just had. These are rules that are not in controversy. They're well established under both the federal rules and the rules of virtually every state. The first rule of importance is that if you have any objections to the answer, to the form of the witness's answer, for example, you believe that it's been evasive or unresponsive or incomplete deliberately, that objection is waived unless you state the objection at the time of the deposition. So if you have any intent to seek court assistance in compelling the witness to give better answers than you have already obtained, in other words, you want to go to court to do what you haven't been able to do through your own techniques, you must state on the record that you're objecting to the conduct of the witness and describe why you believe the witness is acting inappropriately in order to keep from having lost that objection in order to preserve it. In addition, a very important rule present again in the federal rules in virtually every state is the rule that states that an evasive answer is going to be treated the same way as no answer at all. And so one of the things that you can do is object to a witness's answer when the answer is unresponsive and evasive, and say, I object to the answer, it is unresponsive and evasive, and I move to strike it. This clearly conveys to the witness and counsel the objection, and then you can even go on to state that under the rules, an evasive answer is treated as no answer for the purpose of obtaining sanctions, and that you will be able to seek the same sanctions you could obtain as if the witness had refused to participate in the deposition and answer these questions at all. Well, once the witness hears this, that the risk is sanctions, it not only protects the record, but often it also encourages the witness to be more responsive and compliant with what the rules require. Witnesses typically don't understand the rules. You've made the rules very clear. Now, as to the use of video in the depositions, as you pointed out, both the unresponsive witness and the interfering lawyer can be somewhat controlled by putting them on camera.